and the meeting controls. Let me see before I do that. All right. Let's see. It does appear that there is some certification credit that's available today if you use the SHRM activity code, HRCI code. So we'll just take a moment for those of you who just like to jot these down. And we can return to them again at the end of the webinar to make sure that you have those. So today I am delighted to speak with you about understanding the Connecticut Paid Leave Act. Our agenda will include an overview of the Act, some of the key dates, an overview of the leave laws and claims administration, the leave law in action, the role of the employer, putting it into practice, some additional resources, then time for questions and answers. So the Paid Leave Authority came to fruition after legislation was signed into law in July of 2019. And our primary purpose is to serve a growing need within the state of Connecticut for families that need to take time off to take care of their families or themselves without having to worry about lost income. And we do that by providing pathways, not sure what happened here. We provide the Connecticut workforce pathways to accessible paid leave benefits, and we empower employers, administrators, and healthcare providers by giving them tools for understanding their roles and providing support to navigate the program. We have 5 primary responsibilities at the authority, and they are outreach and engagement, like we're doing today, to develop the policies and procedures needed to run the program. We establish the contribution rate to the trust fund, and we receive those contributions. We audit and approve private plans, and we administer the claims for paid leave benefits. So there are categories of employers who are covered by the statute and those who are not. Those who are covered include employers who have 1 or more people working in Connecticut, and that includes not-for-profits and private sector employees with a unionized workforce. In some cases, they are the same. There are nonprofits that are also private sector employers with a unionized workforce. Sole proprietors and those who are self-employed have the option to participate, but if they do so, they must remain in the plan for a minimum of 3 years. Those who are not covered and those employers who are exempt are the federal government, the state of Connecticut, with the exception of covered public employees. The same is true for municipalities and local or regional boards of education. Non-public elementary and secondary schools are always excluded. So just a bit more about the covered public employee. Who are they exactly? They are non-unionized employees of the state of Connecticut. They're unionized employees of the state who collectively bargain to be included in the program. And with respect to municipalities and local and regional boards of education, if those entities have bargaining units and those bargaining units collectively bargain to be included in the program, then all of the employees of the municipality or all of the employees of the local and regional boards of education are also then included in the paid leave program. The program is funded by collecting 0.5% of wages and contributing those to a trust fund that is managed by the Office of the Treasurer. So starting January 1, 2021, employee, sole proprietor, and self-employed contributions of 0.5% will be collected and then remitted no later than the 30 days after the end of the quarter. The employer is responsible for collecting those wages and remitting them to the Paid Leave Authority. We then receive those contributions and we validate that the employer is in fact remitting all of the contributions that they should based on their payroll. Those contributions are then deposited into the Paid Leave Trust Fund, which, as I mentioned earlier, is managed by the Office of the Treasurer. And just a word about the trust fund. The trust fund is protected by law from being swept into the general fund, and it can only be used for the administration of the Paid Leave Authority and to pay benefits and for no other purpose. And then finally, those trust fund contributions that are being collected in 2021 will be used to pay benefits in 2022. Here are some of the key dates that might be of interest to you and your clients and your employers. The paid leave website launched on September 4th at ctpaidleave.org, where you will find an abundance of information about paid leave for employers, employees, third-party administrators, and healthcare professionals. Registration officially opened on November 23rd, and employers will begin deducting the contribution of 0.5% from wages starting January 1 of 2021. And then on January 1 of 2022, employees, sole proprietors, and self-employed individuals can begin to submit applications to receive benefits. Then let's go through a brief overview of leave laws. What are some of the reasons for leave? Under the statute, you can take leave to create or expand your family through birth of a child or the growth of your family through adoption or foster care. You can care for a family member with a serious health condition or your own serious health condition. If you have what's known as incapacitation during pregnancy, you can, hang on a second, okay. If you have incapacitation during pregnancy, you can take up to 14 weeks of leave. Special leave is available for a family member that is injured in the military, known as military caregiver leave, and qualifying exigency leave is also available when a family member is called up to overseas active duty. In Connecticut only, family violence leave is available for up to 12 days. So here's a comparison of the current Connecticut Family and Medical Leave Act as compared to what it will look like when the law changes in 2022. We now know that the current law applies to employers with 75 employees or more. We have our 12-month work requirement and our 1,000 hours worked requirement and job protection available after 12 months of leave. With those criteria met, a person can take 16 weeks of leave in a 24-month period, and the employer can require the employee to exhaust all of their accrued time to cover their paid time off. The law looks very different come 2022. Again, as we mentioned earlier, it applies to employers with one or more employees, and job protection is available after 3 months. There is no hours worked requirement under the new law. Income replacement is available if the person is currently working in Connecticut or they had been employed and working in the state during the past 12 weeks immediately preceding their request for income replacement. And they had to have earned $2,325 in the highest earning quarter of the first 4 of the past 5 quarters. Rather than having 16 weeks of leave in a 24-month period, they will now be available up to 12 weeks in a 12-month period, with an additional 2 weeks available for incapacitation during pregnancy. And another important point with respect to a change in the law is that while an employer may require an employee to use their accrued time off, they can no longer require them to exhaust all of their leave. They will be entitled under statute to keep up to 2 weeks of their accrued leave. Here's just a brief overview of the leave laws. So there is a rather lengthy list of the laws that provide job protected leave. We know they include FMLA on the federal level and the state level, workers' compensation, the Americans with Disabilities Act, the Pregnancy Disability Act, and what we know as SFIPA, which is the Connecticut Fair Employment Practices Act, which now covers small businesses with 3 or more employees. Laws that will require or offer income replacement will be the Paid Leave Act, and workers' compensation obviously will remain. So the primary difference for the reasons for leave under the federal FMLA and the Connecticut law will be the expansive definition of family member. And here is where there may be some challenges in running state and federal FMLA concurrently come 2022. Under the federal law, which we don't anticipate any changes to be made anytime soon, we know that an employee can take leave to care for a parent, a spouse, or a child who's under 18, or they can be over 18 if they have a disability. Under the Connecticut law, an employee will now be able to take leave and receive paid leave benefits also to care for a parent, a spouse, a child of any age now, a sibling, a grandparent, a grandchild, or an individual who's related to the employee either by blood or affinity, meaning that there's a close association that is essentially the equivalent of those family relationships noted above. So here is related by affinity, a proposed definition. The Paid Leave Authority, specifically Erin Choquette as our general counsel, drafted a glossary of terms that can be used to better interpret the statute, particularly when it came to the definition of family. So the proposed that glossary of terms was posted for public comment in the Connecticut Law Journal, and it included this definition of related by affinity. So some of the examples that are listed here, it's not exhaustive, of course, but these would be some of the reasons that you might want to use to determine whether that person has a relationship by affinity. The proposed definition is any person with whom the employee has a significant personal bond that is like a family relationship, regardless of a biological or legal relationship. So an example might be a foster child in the same home where the employee was a foster child and with whom the employee has maintained a sibling-like relationship, although they're not related by blood or legal relationship. Or here's another, an unmarried significant other of the employee with whom the employee maintains a familial spouse-like relationship, despite their lack of a legal relationship to one another. These slides will be available, so these additional examples will be available for you to examine more closely, but those are just a few of what related by affinity would mean under the expanded definition of family. Here's a general overview of what the length of the leave would be under the statute. The federal leave remains as it is. The Connecticut leave as of 1/1/2022, the job protected leave means that a person can take 12 weeks in a 12-month period. Some exceptions to those are 26 weeks in a 12-month period for a family caregiver leave, up to 12 days out of the bank of 12 weeks for family violence leave, and an additional 2 weeks for incapacitation due to pregnancy. The paid leave benefits, you will see, also mirror the job protected leave benefits as well. And again, here's a brief review of the eligibility requirements under federal, current state law. Under federal law, the family FMLA will, as it will appear in 1/1/2022, and then the paid leave benefits. So simply put, when the law changes about a little more than a year from now, job protection is available after 3 months, and there is no hours worked requirement as noted earlier. In order to get access to paid leave benefits from the authority, we have the number of quarters that you need to work and the $2,325 that you need to earn in one of those the highest of those quarters. And again, the person has to either have been currently employed and working in the state, they had been employed and working in the state for the 12 weeks immediately preceding their application for leave, or they're a sole proprietor or self-employed person who's opted to participate in the program. So for an employer, what does claims administration really look like? So with respect to paid leave, the employee would apply to the paid leave authority for those benefits. So let's just take a step back here. The employee will come to you as an employer or come to an employer and say, I have a qualifying reason for leave and I've worked my requisite amount of time. We'll assume job protected leave for the purposes of my example, and I'd like to take some time off. Well, that person may have only accrued a few days of leave, nothing that would be close to the time that they need to take off to attend to, let's say, it's their own serious health condition. Let's assume they need 3 weeks off. They may be granted that amount of time off from their employer, but they would not have enough money to cover, enough accrued time to cover all of their leave. Under those circumstances, that employee would apply to the paid leave authority for benefits. We would validate that application with respect to their eligibility, their total earnings, and the reason for which they are seeking leave. We would calculate their benefit amount, communicate with the employer and the employee regarding their actual covered absences, and whether or not the employee has any access to any other benefits that our employer offered to help them with their paid time off, and then we would issue benefits payments. So the formula for providing paid leave benefits from the authority looks like this. If the applicant's base weekly earnings is less than or equal to the Connecticut minimum wage multiplied by 40, then that person receives essentially 95% of their base weekly earnings. If it's more than that, then the 95% of the base weekly earnings is part of the calculation, including another 60% of the base weekly earnings. It's multiplied by 40 plus the 60% of the base weekly earnings also multiplied by 40, but the total weekly benefit amount is capped at 60%. So I just use this example because the formula is very convoluted in the way in which it's listed and described in the statute. So here is Mike. Mike works for a childcare provider. He makes about $800 a week in wages after taxes. He needs to take some time off to care for his sister who's receiving medical treatment. So we're going to assume that he's worked for the employer for at least 3 months, so he has job protection. So 95% of his wages is $760, and that would be the maximum benefit amount he could receive. We now know that in the state, the minimum wage is $12 an hour. So the first thing we do is calculate what he would earn at 40 times the $12 an hour, which is $480. That still does not bring him to his 95%. So then we calculate an additional 60% of the 800, which happens to also be $480. And together he would get $960, but the maximum weekly benefit that he could get is 60 times the fair minimum wage. So his weekly benefit is capped at $720, which is pretty close to the $760 of his 95% of his wages. Now I'm going to ask my colleague, Erin Choquette, to join me to walk through the scenarios of other benefit types of calculations.
Thank you, Andrea. Just all depends on how you like to do your math, right? So we have in this scenario just a couple of different examples. I use the $15 minimum wage, which will take effect in Connecticut in a couple of years, just because that makes the math easier for me. So in scenario one, I just have Lee, who earns $500 a week. If you multiply $500 a week by 95%, you see that Lee's benefits would be $475 in income replacement. Alex earns $1,000 a week. $1,000 is obviously more than 40 times the minimum wage. So we would use that two-part calculation that Andrea mentioned. So 95% up to the 40 times the minimum wage plus 60% of the difference between what Alex earns and 40 times the minimum wage. In that situation, you've got $810, which is still less than $900. So Alex's income replacement would be the $810. And finally, we've got Riley to just show the example of a person who, when you do that two-part math, you see that Riley, if you do the math equals to $960, which would be more than 60 times the assumed minimum wage for this example. And so Riley would be receiving the $900 a week, like the example that Andrea just gave to us.
Right. Okay, thank you, Erin. So here's the role of the employer. When an employer has an employee coming to them, asking them for time off from work for what might be a potentially FMLA qualifying event, we do ask employers to engage in this two-part analysis. The first is to really ask whether or not that employee is eligible for job protected status, not just under the FMLA, but perhaps under one or more statutes, and whether that employee is eligible for any income replacement while they're on leave. We find that it's really critical that both questions are addressed each time so that no opportunities for job protected leave or income replacement are missed. As we mentioned earlier, the first analysis would be whether or not the employee has job protected leave. So under federal law, we know it's 50 employees or more, the 1,250 hours worked. The reason for leave is covered under one of the covered reasons under FMLA on the federal level, and they haven't exhausted their entire leave entitlement. Come 2022, you'd be asking the same question, whether you're a covered employer, if they've worked for you for 3 months, if their reason is also covered by state FMLA, and if also they have not exhausted their leave entitlement. So that would be the general analysis. You then also ask whether or not that employee may be eligible for other job protected leave, such as the ADA. We know that when you engage in this analysis, you might determine that an employee may be eligible for federal FMLA, state FMLA, both of them running concurrently, neither of them, but perhaps a job protected leave as a reasonable accommodation, which could be the ADA, or no job protected leave at all. Being, the HR professionals that you are, I know that you probably operate in an abundance of caution, and you would probably let your clients or your company know that they should be engaging in a complete analysis of leave for which an employee may be eligible. And I went back a little too far. Let me go one more slide. All right. Then we'll talk a bit about eligibility for income replacement, because workers' compensation still remains available as an option if the person meets the criteria. It's important to know, though, that the statute specifically excludes eligibility for benefits from the paid leave authority if the person is receiving workers' compensation benefits. So if they're not, they may be eligible for benefits under the paid leave authority and or any other employer provided income placement benefits, which would be sick leave, vacation leave, PTO, short or long-term disability. Finally, here's what we like, just as a summary, what we like to let employers know, that they can let the employee know if they have a qualifying reason for leave, obviously with the medical certification from the appropriate healthcare provider, not hair care provider. You can tell it's been a long day for me. The healthcare provider. The paid leave law doesn't really require any existing changes to existing policies, with the exception that the employee must be able to retain their 2 weeks of vacation, sick, or related PTO. The employer would let the employee know that would be required to use some or all of their accruals, obviously with that 2-week caveat, and then they may let the employee know that they can apply for paid leave benefits through the authority. The employer does not make the determination as to whether the employee is eligible for paid benefits from the paid leave authority. The authority makes that decision when the person comes. The employer is making the determination whether that person is eligible for leave, whether it's job protected or not. We determine whether or not the person can get paid for that leave. If the employer has a private plan, then the employer is responsible for not only determining whether the leave fits within the criteria of the law, but they're also required to determine the payment. So let me just say a little bit about an employee that might be eligible to receive benefits from the paid leave authority, even if they are not eligible for job protection. And this can happen under this circumstance. Because the law requires that eligibility can occur if a person has worked 12 weeks for an employer immediately preceding their time for applying for paid leave benefits, and they have to earn that $2,325 within that quarter pay time period. You may have a person who may have worked for a previous employer immediately before the time they come to you as an employer and may otherwise qualify for paid leave benefits, but would not qualify for job protection because they've not been with you for 3 months. And under those circumstances, you can then make a determination as to whether or not you will hold that person's job open for them, whether you'll invite them to reapply, or there's some other arrangement that you would make. But we just want everyone to know that that circumstance could arise, that employers should be prepared to address it when it does. Okay, I think we've already talked about this. So let me just talk about putting it into practice. These are Attorney Choquette's slides, and she loves Warner Brothers cartoons. So, we'll talk about these a little bit. So here's putting the law into practice. So Acme Industry has 100 employees, so we know it's covered by the law. And Wile E. Coyote has been a full-time employee there for 10 years. Given his antics, he probably has a pretty significant discipline history. But despite that, he has 4 weeks of sick leave accruals and 2 weeks of vacation time. He does hurt his hand in a non-work related fireworks accident, and he now needs to be out of work for 8 weeks. So we know that in answer to the first question, he is eligible for job protected leave under the statute in 2022. And we also know that he would be eligible for some kind of income replacement, but let's see what that would really look like. All right. So here is a chart that kind of outlines what he would be eligible for. So we look at the Connecticut FMLA, and because he's worked for the requisite amount of time for the employer, he does have job protected leave for the entire time that he will be out. He also has his federal FMLA that's running concurrently. He does have a number of sick leave accruals that he can use for his Connecticut and federal that are running concurrently. And then you can see once those are exhausted, he can then come to the paid leave authority for his wage replacement benefits for the remainder of his time for his recovery from his injury. And here's another with a smaller employer and a part-time employee. So we have Bionics R Us, has 20 employees. They're all working in Connecticut, and Janice works part-time, and she has done so for 2 years. So her employment status as a full-time or part-time employee is really not relevant here because remember, there's no hours worked requirement. She does have 6 days of accrual and 3 weeks of vacation. And she is trying to get out and stay healthy, but unfortunately she breaks her leg when she's running with her dog. So again, we ask ourselves that two-part analysis, job protected leave, income replacement benefits, and what do those look like? Here is Jamie. Jamie is eligible for Connecticut FMLA and Connecticut paid leave, but not eligible for federal FMLA. And we know because she's probably not met the hours worked requirements and the length of time. So she's got job protected leave because she's worked for 3 months or more. She has some sick leave accruals and some vacation, which she can use to cover part of her Connecticut family and medical leave. So she will receive some payment. And then for the remainder of the time that she's out for her recovery, she'll have wage replacement benefits available from the paid leave authority. For those employers who have spouses who work for the same employer, this is an important thing to know. So obviously the federal rule remains the same, and the spouses will be required to share their 12-week job protected leave entitlement to bond with a newborn or a child that is new to their family, or to care for a parent with a serious health condition. And under the current state FMLA, that rule is true as well. But under the new paid leave law, spouses will not be required to share their 12-week paid leave benefit for any reason. I've covered a lot this afternoon, and there are a lot of resources, and you can find everything that I've said today can be found on our website, ctpaidleave.org. And on that site, you will find some additional resources, including what we call the employee rights poster, which summarizes on one page everything that employees need to know, including key dates, the benefit payments rate, the qualifying reasons for leave. And there is on the site a contribution calculator, which I will demonstrate in just a moment. There's also something called the employee rack card, which is just a smaller version of the employee. What employers are finding most valuable is the employer toolkit, which is all in one place, everything that you'll need to know about paid leave, and payroll mailer, which indicates on that, which shows that on January 1, 2021, you can include this as, okay, and here comes somebody. Hold on. Yes, dear. Okay, just leave them outside the door. Thank you, sweetie. Okay. Okay, I'm on a webinar, so I'll catch up with you, okay? Go where you need to. Thank you very much. Okay, thank you, everyone. So This paycheck mailer shows that it provides information to employees. You can download it and provide it to your all of your employees that notifies them on January 1, 2021, there will be a notice of a change to your paycheck. Okay. We're here if you need any help. You can use the contact feature on the portal. You can also provide any questions that you might have to this email address. You can send them to support@ctpaidleave.org. Okay. And I'll stop now for a moment because I know there might be a number of questions. And I'll see if I can answer some and then maybe go back to the website in a moment. Turn my camera back on. All right. All right, and so thank you very much for giving me the opportunity to review the basics of paid leave. Were there questions?
So Andrea, I've been going through the Q&As as you've been speaking, but we've just got a bunch that just came in. So I
All
don't know if you
right,
want to start with the ones that just
I'll,
came in.
I'll see what I can do, yes.
Okay. So I don't know, maybe we should start with the private plan option. We did get a few questions about the private plan, if that's an option and whether short-term disability policies would be equivalent.
Yes, so the private plan certainly is an option. Generally, short-term disability policies do not meet the statutory criteria for a private plan, mostly because it has to offer the same or better benefits as the state plan, but primarily because the statute requires that there be a vote held for the private plan. And most policies are not provided to employees by virtue of a vote. So they normally would not meet that criteria. Okay. So I do see some questions in the chat. Are we using the chat or the Q&A? Because I see questions kind of popping up in both places.
We have not been following the chat as much, so they haven't gotten
Yeah.
any answers yet. I've been working on the Q&As.
Okay. So if I could ask everyone to please use the Q&A because that's the place where we can really answer your questions directly, because that's where our staff has access to the questions. Okay. And we'll try to get to the chat questions as best as we can.
So Andrea, there are a few questions, all kind of relating to the issue about letting an employee keep up to at least 2 weeks of vacation or equivalent PTO.
Yes.
Some people are saying they offer unlimited time. Some people are saying, can you require them to use sick time if you've got it separated out? Do you want to talk about that a little bit?
Yeah, and Erin, I may ask you to help me answer this question as well. So if you have it bucketed into sick and vacation and other kinds of leave, you can have them exhaust their sick time wherever that time is. You can have them exhaust that. So as long as they can keep the 2 weeks, the unlimited time is a really interesting concept. And Erin, maybe you can help me out a little bit with the unlimited time because it's more common than I actually thought it was.
Yeah. If your policy is that you just allow unlimited time off to your employees and you don't segregate it in any way so that people have to show that it's sick leave versus vacation, then you may want to consider how that policy integrates with the new requirements, because it is up to the employer to decide whether the employer wants to require its employees to use employer-provided accruals before coming to the paid leave authority. Employers have that right to make that determination under Connecticut FMLA and also under federal FMLA. So, and if you choose to do that, then you have to at least allow employees to keep 2 weeks. So it does create sort of a conundrum, and it really can only be resolved by how you, the employer, wish to handle it. If you want to continue to allow unlimited or unallocated PTO, or if you want to start putting restrictions on it. But
Mhm.
You can certainly require your employees to come to Connecticut Paid Leave Authority if they, before you let them use your accruals. But you want to be thinking about what that means in terms of stacking of leaves.
Correct. So I'm going to try to answer a few of the questions that are in the chat. So Erin, I think that I see you stopped at one point. So I'll try to see if I can answer a few of these. The first is, it does not appear that Connecticut Paid Leave runs concurrently with Connecticut FMLA and federal FMLA, correct? And that's correct. So as of 2022, they will not run concurrently. So remember the current FMLA for Connecticut will change to the new one with the 3-month time period for job protection as one of the changes that I outlined. That will be the new law in 2022, and it does not run concurrently. It will make it more challenging for it to run concurrently with a federal, because the federal qualification will not change. So the next question then is, how do you register as an employer? You go directly to the ctpaidleave.org site, and just as you land on that homepage, you will see a huge call out for register here. And there will be instructions, and there's a video once you click on that will tell you exactly how to register. Okay. Then there's a question that says, if an employee uses employer-provided PTO initially and then transitions to the paid leave benefits, do the employer-provided benefits count against the total benefits available from the state? So I'm not sure I quite understand this question, if we're talking about the dollar amount that the person has been paid out in total benefits or the time. So I think if we're talking about the PTO in terms of, if we're talking about the amount of benefits that they get in terms of from the paid leave authority, we are counting what we've paid to them in their benefits. So Erin, correct me if I'm wrong. So if they've exhausted all of their PTO, and then they come to the authority because they've only had, let's say they had 6 weeks and they used 4 of them, but they have another 4 weeks that's not covered, then they're entitled to 4 weeks of paid leave from us. Then they would still be entitled to another 8 weeks of paid leave from us because they've not exhausted all of the 12 weeks that they have available in paid leave. So I think that's the question I think you're asking me, Mark, and that would be the answer. So then the next question is, when would the employee apply for benefits, before or after they use their PTO? So in the examples that we provided, the person would come after they've used their PTO, again, with that 2-week holdback. So we would want the employer can require them to use their time. And we would also be asking the employer whether or not they have any time that's available that they can use. And then we would have them use that and then apply for benefits. And then finally, the next question I see here in the chat is there assistance to the employer to set this up in the payroll system? So I'll answer that in 2 parts. First, if you are using a large third-party administrator, such as ADP or Paychex or Check Writers, any of the large ones, they are very familiar with this. We've been working with them since April to develop all of the systems and the technical criteria to be able to withhold the 0.5% and also remit it on behalf of the employer. So if you speak to your local representative and they don't have any idea about this, please let us know that at the Paid Leave Authority, or push back on them to say that they should know, because we've been in constant communication with them, meaning regular hour-and-a-half meetings every other week about paid leave. So they're well aware of that. If you're using QuickBooks, there will be a release of QuickBooks and an update to the web-based product on December 18th, so that you will be able to withhold the 0.5% through QuickBooks. So those are all the questions that I see that weren't answered in the chat. I don't know if there's more in the Q&A, Erin.
There are still some going in the Q&A.
Okay.
I've been trying to go through them as I can, but I don't know if you want to click into that or not. There's 24 unanswered questions, so there's still a fair number to go.
We'll take a look. Okay. So can you tell me what the state identity is? Is this a tax ID? So the state identity, I think if we're referring to the registration process, is not a tax ID. The state of Connecticut has recently opened a website called Business. It's internally known as Business One Stop. It's known as business.ct.gov. Gov is it is literally designed to be one place where you can go create one identity for the state, and it should allow you to then navigate to the other agencies that you would interact with regularly, which would be the Department of Labor, the Department of Revenue Services, and also the Paid Leave Authority. That's what that state identity is. And once you create it, you only need to create it the one time. You'd use those credentials to sign on to our site. Okay, so the next question is, I'm a bit confused that an employee may be required to use their PTO, but they must leave the employee with up to 2 weeks. Is that at the employee's discretion to leave themselves less than 2 weeks? It's the up to that is confusing to me. Okay, so if the employee wants to use less than the 2 weeks, I think the question is, does it have to be the 2 weeks? It's the statute was written in a way to give the employer and the employee some flexibility around that, but really what it's designed to do is to not have the person exhaust all of their leave when they're taking family medical leave. So they have to have a minimum of the 2 weeks, maybe I can say it differently. But if they want to use some of that, they can, but they can't be compelled to. So that's really the difference. All right, so then there's another question. Does this mean that non-union municipal employees are not covered since they do not have a contract? That's true, unless the bargaining unit votes to participate, and then everyone who works at the work site is then in the plan. Okay. So can an employer require that employees use their sick leave before their paid leave? Well, yes, they can. So if an okay. All right. So how does this work in conjunction with short-term disability? So the way that it works with short-term disability obviously depends on the short-term disability plan. Some of the plans require that that state available benefits be exhausted before access to short-term disability is available. So in that case, the person would come to the paid leave authority first, they would apply for paid leave, and they would get that. And once that was exhausted, then they may be able to apply for short-term disability. But every case is different. So we're just offering some general guidance on that. And what we're asking is that every employer really speak with their benefits coordinator or benefits administrator to make sure that there's proper benefits coordination. We will always be calling or communicating with you and asking about other available leave that the person might have. I think I answered. I think, thank you. Actually, thank you, Mark, for moving your question into the chat. I appreciate that. Thank you. All right. So we have choir members who only earn a few $100s or less a month. Would they be subject to the deduction? If the choir members are employees, then yes, they would be subject to the deduction. I know the question we get quite often is, well, they may not ever earn enough to qualify for the benefits. And we do understand that. But the definition of employee is pretty expansive under the statute. So then there's not a way for us to eliminate participation because based on earnings. So that's the answer to that. Okay. Connecticut employers must also comply with the paid sick leave law that applies to service employees, which the paid family leave law neglected to harmonize with. Why would an employer continue to provide any additional paid sick leave that is not required by the law? So I'm not sure that an employer would, well, let me just answer it a different way. So yes, it is true that the family and medical leave law is different from the sick leave law. So I don't think we're asking employers to provide any additional paid sick leave. What we're saying is that the person is, if they've met the criteria for family and medical leave, they're still entitled to that leave, but now that leave is paid. So if you were an employer that was large enough before to have offered that leave, we're now saying that you have to comply with the new criteria. And on top of that, that person is then entitled to get paid for it, whether they use their PTO and exhaust it, with the exception of the 2 weeks, and then they can come to the paid leave authority. So you still have both obligations in an instance. So that's that. Let's see, I would assume that this applies to quasi-public agencies as well. It does, including the quasi-public agency that's responsible for administering it. So we will be paying into the fund as well. When will new forms be made available? There will be forms that will be made available. We're in the process of designing those forms now. So they will be made available. We're trying to model them on the current forms so that there's not such a huge difference if you're accustomed to using the state or federal FMLA forms. Okay. In many cases, a small business owner with less than 2 employees, we usually don't offer any benefits other than vacation time. What happens if the employee refuses to contribute the 1/2 of 1%? Well, that's an excellent question, and we hear it often. If they refuse to contribute the 1/2 of 1%, then when they apply for leave at the Paid Leave Authority, their benefits will be denied because the contribution is required. But I want to make it very clear, it's not an opt-out. And so we should really emphasize that with the person, that they do have to, and you as the employer must withhold it. So it isn't as if they have to refuse, because the statute is written that every employee shall contribute. So they may object to it, but they still have to contribute. Let's see. Our company provides 60% income replacement through our short-term disability for 13 weeks. Is the employee eligible for Connecticut FMLA income replacement for the difference in pay loss? We run short-term disability and FMLA concurrently. Not sure I quite understand this question. Let me read it one more time. Okay, 60% income replacement, short-term disability 13 weeks. Would they be eligible for income replacement for the difference in pay loss? They could be eligible for income replacement from the authority for the difference in pay loss, even if you run your short-term disability and your FMLA concurrently. They could be. Again, this is where the benefits coordination comes in, and I see that Erin answered the question. There is no legal way for anyone to refuse to participate. Like I said, they may give you a hard time, but you as the employer have an obligation to withhold it. Okay, let's see. I think I saw a question here. We have employees who report to work for Connecticut, but they live and work in New York, and they already have to pay into that program. Yes, we get this a lot. Do they have to pay this too? If they report to work, here's the general rule that we've been providing. If you have an unemployment obligation or a payroll tax obligation for that employee in this state, then they're considered an employee under the statute, and they do have to contribute. We do have some folks who work part of the time in Massachusetts, as an example, and part of the time in Connecticut, and they are contributing to both programs. They're also then eligible to apply for leave in both programs. We haven't quite figured out how that coordination will work. But if you have people who are just coming in to pick up stuff and you don't have really an employee obligation for them, then the answer is no. So you have a Connecticut company with New York employees. Again, if they're not working in the state of Connecticut, even though you're a Connecticut-based company, but they're New York employees, then they're not subject to the withholding, but they're also not going to be eligible for benefits here. All right, so if the employee lives in Connecticut, but their employer is in Massachusetts, again, I think the answer to that is that if they live here, but they work in Massachusetts, then it's not based on residency, it's based on where they work. So they are contributing to the Massachusetts plan, and they would not be contributing to the Connecticut plan. Then the next question I see is, if the requirement for job protection portion of the leave is 3 months, then the employee would not be eligible until 3 months after 2022, or is this just an income replacement portion for which the employee is eligible? So it's interesting because it's actually a little bit of both. So they need to have worked 12 weeks for an employer for the income replacement, and it could be you as an employer, or it could be another employer, but they've worked less than 3 months for you, so they don't get any job protection from you. So if they've worked 3 months for you, they're then eligible for job protection and the income replacement from the Paid Leave Authority. If that answers your question, Adam, it does get a little bit confusing.
Andrea, can I just add to that?
Yes.
The eligibility issue for job protection will be, an employee comes to you on January 5th, 2022 and says, I'd like Connecticut paid leave. I'd like Connecticut FMLA. You will look and see, have they worked for you for at least 3 months as of that day, as of January 5th? So it's not, they don't have to wait until whatever that is, April of 2022 to ask for job protection.
Okay, thank you for clarifying that, Erin. I often forget to say that. So thank you. Here's another. Our TPA says they will register our company and then I don't have to worry about that. That is true. But does my company need to register for the claims piece of this? A colleague thinks we may have to register. I'm confused. So no, you do not have to register for the claims piece. You're simply registering for the collection of the 1/2 of 1%. Your employees will come to us and apply for benefits, and we will handle the claims piece. So your involvement will be, perhaps we will call you for benefits administration with respect to benefits coordination. And if we need to verify employment for any reason, we will have access to information from the Department of Revenue Services as well as the Department of Labor. And if we can't fill in any gaps from those two sources, then we will probably be in touch with you as well. So next is, if an employer has employees who are paid wages for working remotely in New York and also paid Connecticut wages, do we separate New York gross wages and not withhold versus Connecticut gross wages and withhold? Excellent question. And so the answer in short is yes. So you're only remitting the 1/2 of 1% on the Connecticut wages. And it's not gross, it's actually the FICA number. So once you've calculated what their FICA number is for Connecticut, you're taking the 1/2 of 1% from that amount. And obviously we're not entitled to anything that is earned in New York. So those wages would not be subject to the withholding. Okay. Let's see. So employees will not receive 100% of their pay as they do now, right? If they vacation or PTO, that's correct. Can the employee use their accrued time to make their pay whole? They can use it in that way if that's something that you allow under your policy. That is certainly something that's available to them if they want to do that. So yes, if your TPA is also your payroll provider, then you're pretty much all set with respect to the registration, if they're offering that for you, and the withholding and remittance. Excuse me. All right, let's see. Yes. So, well, okay, I guess Erin answered that because it is gone. That question is gone. Was this recorded and will it be available? That would be helpful since the overview. Well, thank you very much for your compliment. And yes, the recording will be available. Amber, perhaps you'd like to let everyone know about the availability of the presentation after we're done here today. Amber?
Sorry, I realized my mic was still off when I was talking. Yeah, so
Okay.
hello everybody, everyone who registered for the webinar will receive an email that just says, thank you so much for joining us. And in that email, you'll receive 2 links. One link is to our YouTube page, which has recordings of all of our different topics of webinars. And the other link will include a copy of this presentation. So all of you who registered will receive that. We will also provide this presentation in PDF form to Anne and SHRM, and they can distribute that to anyone else who would like to receive that.
Thank you, Amber. Mark posed another excellent question about state and federal laws that allow the reduction of salaried exempt employees' weekly salaries for less than full day absences. And will the paid family medical leave fill in for such partial day absences, and how small of increments? We're actually determining that right now as we speak, Mark. Erin and I just had that discussion today, as a matter of fact. It's really with respect to intermittent leave. So it's a little bit of a variation on the question that you're asking. So if the person is having their pay reduced because they're taking intermittent leave, they would be able to apply to the paid leave authority for that intermittent leave. We're thinking that the person would be paid after having accrued a certain number of hours of that leave, which will probably be about 8 hours, and then they would receive a check for that. Student workers is a great question about student workers. They come up so often. Do not pay into FICA or Medicare, so can I consider them to be exempt? Interestingly, the Department of Labor says that if your student workers receive a W-2, they consider them workers and employees under the statute, and they do have to contribute their 1/2 of 1%. So we're going to get a little more clarity about that. So it doesn't seem as if the criteria of whether or not they pay into FICA or Medicare is as a criteria that is one for determination of participation in this particular program. Thank you for both of you for your kind words about the presentation. And I think we did answer the question about unlimited time. And that's all that I see now, Erin, in terms of the answers that are open. Let's see. And that's it, I think. Okay. I think we are right at time. Anne, is that correct? Did we have about an hour for the presentation today? And you are on mute.
We had up to an hour and a half if there are other questions as people are
great.
Thinking about what we've discussed. I'm trying to absorb it all. It's like
it's a lot.
A lot. And you
a
almost,
lot, I know.
Probably at 9 o'clock tonight, I'll have another couple of questions.
So, Anne, if we have a little bit of time, might I ask everyone to indulge me? I could just do a brief demonstration of the website where some of this information might be found. Okay,
that would be great.
Appreciate that. Okay, that'd be terrific. So let me share my screen again. Let me see. Okay, so I'm gonna. All right. Oh, that didn't quite go. So hang on a second. All right. So if anyone can let me know that they can see my screen, anyone at all?
Yes.
You're up, Andrea.
Excellent, thank you. So here's the Connecticut paid leave site. It is at ctpaidleave.org. I am on the homepage, which is the landing page. So in answer to one of the questions that had been posed earlier, how do I register my business? It's right here. As soon as you get on the site, it tells you exactly what you need and you don't have to scroll down and find anything. And on the left are the 3 key dates when registration open, when payroll deductions begin, and when paid leave benefits will start. Just very briefly, let me just go into the register your business just for a moment so I can just show you a couple of things. First, you'll see there's a call out at the beginning saying you do have to create your account with, it should say business.ct.gov, so make sure we'll get that fixed. And then here is a list of how to prepare for business registration. Why do you need to register? Because it is a vital step. You'll need those credentials in order to register here. All businesses should register by December 31st. You will submit your contributions no later than April 30th of 2021. And if you're an employee, you don't need to register. So here, let me just show you. If you're an employee or a company administrator, there is a checklist here that's available to you that you can print. If you need to learn more about paid leave before you start, you can certainly click here. It will navigate you through the site. There's also a registration tutorial video. Now, I know I'm a visual learner, so I love these videos. And it tells you that you need to create a state identity, you need your FEIN number, and your NAICS code. So this checklist is here. I'll be honest with you, out of my own pet peeve, I hate sitting down, filling out things and registering and finding in the middle, I need my birth certificate. I need 3 different forms of identification to scan. I really wish you would have told me before I got halfway through the process. So in order to avoid that, we do have this checklist that's available where you can get the information that you need before the process starts. We also offer a webinar on how to register your business, and you can find that on the events section of our site. I'll just go there very briefly. And let's see if it'll load up for me. Sometimes it takes a minute. Okay, it just doesn't want to do it right now. It is giving me a hard time right now, so I'll come back to that. But there's usually a calendar here, and you can go and you can find the webinars and you can sign in. So let's see if it'll come back another time for me. Once you've learned to register your business, there are call outs here for employees, employers, third-party administrators, and healthcare providers. There's also a long and exhaustive list of frequently asked questions in virtually every category that you can think of. You can open some or all of them, and you can print all of the FAQs. They're also available in video. We update these FAQs regularly. The video has the most frequently asked of all the frequently asked questions, but we really encourage people to visit this portion of the site pretty regularly and look at how we've updated the frequently asked questions. Here, there are videos for employers and employees, and the entire site is available in both English and Spanish. You can join our mailing list. If there's more information that you need, again, I've shown you where the FAQs are. You can use this contact us feature if all else fails on the site and you need to direct a specific question to us. We are not large enough to have a call center as much as we would like to. There are really only 8 of us that work at the authority with a little bit of help from United Way, who's helping us with the contact us feature. So if you enter your information here and tell us the best way to reach you, someone will get back to you. Go back to the home page. Let me go to employers. So this is a page specifically with resources for you as employers. The employer guide video that I showed you on the home page is available here. Again, both in English and Spanish. Summary and everything that I talked about is all here. Who administers the program, all the key dates for registration and payment remittance can be found on this page for you as well. If there's any question about that, what your role is as an employer to make the payroll deductions, to submit them, and to communicate with your employees about paid leave. Well, how do you do that? Because there's so much to be communicated. Here are all of your resources in one place. First of all, there's a one-page fact sheet that you can download for yourself. Open it up. That basically explains everything I had in that slide presentation on 8.5 by 11, two-sided. So it's all right here. There's a similar page that's also available for your employees on the employee page. If you'd like everything together, we now have a 24-page employer toolkit. This is probably one of the most downloaded documents on our site. I won't go through all 24 pages. I'll just share with you the table of contents, and you can see here that it virtually covers everything that we have, including how to apply for a private plan, what to do if you file your own taxes or a third party files them for you, meaning you have a third party administrator. How do you register? The employee communications resources that I showed you are all in this one document. For sending additional information to your employees, there are 2 pieces of information that we highly recommend to you. First is what we call our paycheck mailer. Again, I'll download this so we can see it without the pages in front of it. Okay. And this, again, is one of the most frequently downloaded documents that we have on our site. It is the notice to employees that the 0.5% deduction is coming. We have had employers download this document and email it to their employees, sometimes with a cover memo, sometimes with a very brief email, but it explains essentially what's coming. And this QR code that's here will bring your employees to our contribution estimator, which I will demonstrate for you in just a moment. The other document that you can include is the employee poster. Again, so what we're finding is that employers are downloading the paycheck mailer and the poster and sending them together electronically, or posting them on their intranet sites as sources of information for their employees, because it is not your job to put this stuff together, our job, and we just want to make sure that it's available to you in an easy format that can be downloaded and printed and shared. So let me then go to the employee site for just a moment. It looks very much like all the others, so we try to have a consistent look. Again, key dates for employees are here, so they can know when their contributions begin, when they can apply for benefits, and when benefits will be available. There's an explanation with respect to what those benefits are. That's all here, including that very convoluted formula. And our hope is that pretty soon we'll actually put a real live example so that the person can see how the formula would actually be applied. The qualifying circumstances for leave are also outlined here, as well as their role as an employee. But one of the most frequently used tools on this part of the site is this contribution estimator, where the person can put in whatever they earn weekly, bi-weekly, monthly, or quarterly, whatever their pay cadence is or income cadence is, and get a general idea of how much they'll make. So if they know that they make, let's say, $1,000, okay, so it doesn't really matter if it's weekly, monthly, whatever that frequency is, they want to estimate the out of that $1,000, they're going to be contributing $5 of that towards the paid leave trust fund. There, we have people that I think they spend a really significant amount of time with their contribution estimator, especially those who are sole proprietors and self-employed who may have a number of variations in their income. So this is a tool that's available, and we really strongly encourage you to have your employees come and use this tool so that they don't have to keep asking you how much is coming out of their paychecks. So we have a lot of people that use that. That is essentially the site in a nutshell. There's a lot more to it, but I don't want to keep you all evening. And that is the paid leave site. So I will stop sharing my screen right now. See if we have any more questions. Okay. All right. So, Anne, I hope that was helpful. And it's a place for you to go back to so that you don't have to memorize everything I just talked about. So it's all there.
Yes, I'm sure everyone will find all of the information very helpful.
Good, good. Okay. Let's see. Okay, there's a few more
Andrea, there
questions.
is a question about the the specifications for the contributions. And I know that we have them, but I'm not sure if that's something we
Yes.
can describe or if we just send them to the website for that.
I think we want to send you to the website for that. I know that so how are the contributions reported? There is a specific format. I am not really the best person to do that, and you will be able to find it on the website. If you drop your email in the chat for me, I'll make sure that someone gets back to you with exactly where you can find it. Okay. All right. So, Erin, have you answered these other questions? If the employer already paid out 12 weeks, how can we verify that they may be exempt?
Yeah, I was just looking at that. I think that this employer is saying that they're already providing paid benefits to their employees, and so they want to be exempt. And I think the answer, which is worth repeating, is there's either the opportunity to participate in the Connecticut Paid Leave Program or the opportunity to apply to the authority to offer a private plan to your employees. And the private plan either has to be an insurance policy using an approved declaration, or you have to have a self-insured policy using the forms that we have on our website. You can't simply say we have leave policies which are sufficient. That's just not what the statute allows. There is a website, there's a webinar that we offer that gets into much more detail about the private plans. So anyone who's interested in seeing if that's something that they could offer to their employees, or if what they have is something they could tweak to make it compliant, we encourage you to sign up for the private plan website or webinar, which you can access through ctpaidleave.org in the events calendar.
Unmuted. All right. I think that's it. Yes.
Yeah.
So,
Andrea, the other questions that I did answer were related to, again, the question of having the employers register as well as having the payroll providers register. And I was saying that there's employer information that the employer would have that we need in the registration process, and then the payroll providers provide their separate information. If you have a payroll provider who is offering to register for you, they're going to need that information from you. So you want to make sure that they know what they're offering, and so that they can make sure that the registration is complete.
That's right. So actually, right now, because quite frankly, we didn't anticipate that so that employers would actually be asking their third-party administrators to register on their behalf. We anticipated a workflow where the employer would register so that we can confirm that the information belongs to them. It really was for security purposes. So now we're working through another workflow that will allow the third-party administrators to register on behalf of the employer, but also let the employer know that registration has occurred, so that no one's registering on your behalf and you don't know about that. So we're almost done tweaking that workflow, and then we'll announce that as soon as it's available. So, Anne, I don't see any more questions, and we are really grateful for the opportunity to have been here today. As I said, SHRM was absolutely my best friend when I was running HR at Hark, and I'm really grateful to be here today. Oh, I had all kinds of questions, and SHRM was always there. So thank you for the opportunity to repay the favor.
Thank you very much. And
Sure.
I'm sure we'll be referencing the recording and appreciate that as well. Just a question, with the recording, will it reflect all of the Q&As and chats?
I think, Amber, it has the Q&A. I'm not sure about the Q&A and the chat. It'll have us answering the question, but Amber, maybe you can answer that. I'm not sure.
We do receive a bit of a recording, and in the new technical world, we're still trying to sort out what is what. So whatever content I do receive off that recording and those notes, I can send you, Anne.
Thank you. Well, I'm sure everyone, it's been a long day. I certainly appreciate everyone's time and the content. It's been a lot to absorb. Thank you so much, Andrea.
You're
And
very
team.
welcome. Thank you to everyone. And again, I would like to acknowledge my team, Erin Choquette, Amber Forrest, and Andrea Comer. I don't do this alone, so I appreciate all of the time and effort that they put into making sure these presentations go as we would like them to. And thank you again, and to all of your colleagues for making themselves available this evening. Everyone
Thank
have a
you.
good night. You're welcome.
Good night.
Good night.